A very good day to you, Dr. Asma. We are from Group 1 and we are proud to present on the case review of two cases. The first, Koteng Wu versus Amber Objective Sdn Bhd, and the second, Muhammad Aslan bin Haji Zainal Abidin versus Pegawai Penerima Syarikat Crossmore Pro Sdn Bhd. This federal court case concerning an application to set aside a GID. In this case, the material writ was served by the respondent to the appellant by way of AR registered post. A GID was subsequently entered against the appellant. Nevertheless, the appellant argued that they did not receive the writ. Additionally, the respondent also did not exhibit the AR cards in the affidavit of service. It only provides the document that had been posted by endorsing the day and date of the service. In relation to this, the learned court reasonably presumed that the appellant chose to not make an appearance and subsequently granted the GID. Hence, the appellant filed these applications for setting aside the GID on the ground that the service of the writ by the respondent is defective. The issue in this case is that the law is silent on whether one must prove the person named in the post had received the writ once the writ is served by the AR registered post. Having these regards, the matter before this court to decide is whether the GID in question will enter regularly despite the fact that the respondent does not exhibit the AR cards containing an endorsement as to the receipt in the affidavit of service. As for the judgment in this case, the court held that the presumption of service under Section 12 of the Interpretation Act is a rebuttable one. And in fact, this has been rebutted by the appellants on the balance of probabilities. The appellant's denials of receiving the writ was corroborated by the fact that the respondent failed to produce the AR cards duly signed by the appellants or the authorized representative. As such, this court allows the application and ruled that one must serve the AR cards containing an endorsement as to the receipt if the service is effected by way of AR registered post pursuant to Order 10 Rule 1 of the ROC. In general, Order 10 Rule 1 sub-rule of the Rule of Court stated that a writ can be served either personally to the defendant or by way of AR registered post. Further, Order 10 Rule 1 sub-4, read together with Order 62 Rule 9 of the ROC, stipulated that no GID could be entered if a person who made the service failed to endorse the affidavit of service on a particular such as the day and date of the service or the person on whom the service was served. Additionally, Order 13 Rule 7 of the ROC provides that no GID shall be entered against the defendant if there is no affidavit filed by the plaintiff proving that the writ was duly served to the defendant. Nevertheless, the objective test of due service of writ remains silent in the provisions but may be subject to a rebuttable double presumption under Section 12 of the Interpretation Act. Pursuant to this provision, a service shall be presumed to have been effected if the plaintiff probably addressing, prepaying, and posting by the registered post and is presumed to be effected at the time when the writ would have been delivered in the ordinary course, unless contrary proven otherwise. As such, the Court of Appeal in Chong Wai Ming versus Pembandaran Nasional Berhad held that even though there is no provision specifies the plaintiff must prove the acknowledgement in the AR cards, however, the exhibitions of the AR cards in the affidavit of service is the best way to prove that a writ was duly served. Otherwise, the plaintiff would have failed to contradict the defendant's assertion that they did not receive the writ.
In most cases, it is the court's discretionary power to decide whether or not to nullify a judgment in default. This discretionary power of the courts can be seen in Order 13, Rule 8 of the Rules of Courts, 2012. It is notable that the courts will consider a few aspects when a defendant applies for a judgment in default to be overturned. One of the most typical concerns is whether or not the defendant has merits in defense. In White versus Weston, a defense on the merits refers to the mere raising of an arguable or triable issue. Besides, in the case of Hasil Bumi Perumahan Sdn Bhd and others, the Supreme Court affirmed that the applicant must prove that his defense is not a sham defense but rather raises legitimate concerns as a bona fide reasonable defense that should be tried. Otherwise, the application must be denied. In the current case, the federal court was of the view that there is sufficient merit in the point raised by the appellants in applying for the setting aside of the judgment in default. According to the court, Section 12 of the Interpretation Act needs to be read in its whole context. The only thing that is certain is that it is a legal presumption that can be rebutted by proof to the contrary. Hence, if a plaintiff chooses to serve a read through an AR registered post, he must produce the AR cards in his affidavit of service to show conclusive proof of service. Also, the principle laid down in the case of Tajuddin bin M.K. Sheikh Mohammed is supplied. Per the case, it was provided that if a judgment in default or any other document is sent via AR registered post and the AR card is returned unacknowledged and or not produced by the plaintiff, the judgment in default or any other documents was not considered to be received by the appellant. In conclusion, in order for the courts to seal a judgment in default, the AR card with the endorsement from the defendant or someone authorized to accept the service on his behalf must be produced in the affidavit of service to show that the defendant has been served. If the defendant is served with the documents through AR registered post, the plaintiff should have no problem showing proof of service by producing an AR card. It would be unsafe practice in litigation for simple proof of posting to suffice as a conclusive evidence of service. All in all, in the current case, it is notable that no service of the writ was occurred without the productions of the AR cards.
On 2 October 2009, the application of JID, which is Judgment in Default, was entered against the applicant. However, it was contended that the service of JID was highly irregular as it was received by the applicant 4 years later. The applicant then applied to set aside the JID under Order 13 Rule 1 and under Order 19 Rules of Court without any specific rule cited. The application also has extended the 30 days limit as it was applied 3.5 months later, but no application to the court for extension of time. Therefore, there are two issues that has been raised, which are the first issue, whether the application to set aside the JID was defective and abuse of court process as no proper provision is cited, and the second issue is whether the failure of the applicant to file for an extension of time can be rectified by Order 1A and Order 2. It was held by the court the application to revoke the JID was flawed as Order 30 Rule 1 and Order 19 was not relevant to the application. Order 42 Rule 13 and Order 30 Rule 8 should be cited instead. The applicant should also first file a formal request for an extension of time and give reasonable explanation regarding the delay under Order 3 Rule 5 or under Order 92 Rule 4. Hence, the court opined that the Order 1A and Order 2 should not be invoked to remedy the applicant's total disobedience to the rules.
The earlier provisions referred by the court in the present case is Order 42 Rule 13 and Order 13 Rule 8 of the Rules of Court. Order 42 Rule 13 stated that whenever a party intends to set aside or vary an order or judgment, he shall make an application to do so within 30 days after the receipt of the order of judgment. By referring to the case of Perbadanan Nasional Sdn Bhd and Kuala Lai Ong, the court mentioned that the word shall in this provision is not a mere obedience. Failure to obey is a breach of compliance with the rule. On a side note, Order 13 Rule 8 conferred the power to the court to set aside or vary any judgment in default. Next, the court referred to Order 3 Rule 5 of the Rules of Court. This provision provides an opportunity for the party to redress their lateness or technical non-compliance by filing out an application to extend the time limit mentioned under Order 42 Rule 13. By referring to the case of Tiruchal Bazagaram, anak lelaki Manaka Basigar, and Mahadevi, anak perempuan Nat Chatiram, the court mentioned that even if the request is submitted after the time restriction has passed, the court may still, at its restriction power, specified in Order 3 Rule 5 to extend the time limit. Nevertheless, as mentioned in the case of Khor Sheng Wai and Sungai Wei Leasing Sdn Bhd, when there is a delay, he must render a satisfactory or reasonable explanation of it. The court in the present case also referred to Order 1A and Order 2 of the Rules of Court. Order A stated that the court or judge administering the rules should consider the overriding interest of justice and not just the technical non-compliance with the rules. On the other hand, Order 2 mentioned that non-compliance with the requirement of the rules shall be treated as irregularity that can be remedied.
In the present case, it is apparent that the application made by the applicant was defective as it was not made pursuant to the correct order or rule of the Rules of Court. What the court has emphasized is that the correct provision the applicant should have applied under was Order 42, Rule 13. The decision made by the court in the present case was indeed accurate in dismissing the defendant's application by virtue of the word shall contained in Order 42, Rule 13 is a word of absolute obligation. This is supported by the case of Hong Kui Seong. However, the applicant never sought an extension of time to file the affirmation application nor provided a legitimate justification for the excessive delay. In scrutinizing whether the non-compliance with Order 42, Rule 13 of the ROC by the applicant can be rectified, reference has first been made to Order 3, Rule 5 of the ROC. This can be referred to the case of Ng Han Sing, where the court had in the case ruled that if neither request for an extension of time to file nor an explanation for the delay has been submitted, the application to set aside judgment should be rejected. Accordingly, reference has been made by the court to Order 2 or Order 1A of ROC. The court referred to the case of Tunku Mahkota Johor, which emphasized that the technical non-compliance with any rules may be resolved in the event of a party's omission or oversight. However, Order 1A is not applicable when a party willfully disregards the rules. In light of the fact that the applicant willfully disregarded Order 42, Rule 13 of the ROC, it may be concluded that Order 1A cannot be invoked in the situation at hand. Besides, the case of Pacific Center versus United Engineers also highlighted that in order for the court to use its discretion under Order 2, Rule 1 of the ROC, there must be material to satisfy the court. Referring to the present case, the applicant had deliberately and thoroughly disregarded the restrictions and proceed with submitting the application. For the foregoing reasons, the setting aside application made must fail. To conclude, this case illustrates the importance of referring to and obeying the rules of court when filing for an application. Failure to comply with the preliminary obligation to request for an extension of time under the circumstances of the case must be dealt with strictly, in which the failure to comply will render the application deemed defective or dismissed, or else the provision mandating the extension of time will become meaningless. That's all from us. Thank you.